Hello, everyone, and welcome to the IRO Summit. I am so pleased to be invited back this year to give you your legislative and regulatory update for 2025. So let's get started. For some of you, you may remember me. I've been a repeat speaker over the last several years. I'm Nicole Upano. I'm AVP of Housing Policy and Regulatory Affairs for NAA, and I lead NAA's advocacy with the Trump administration. So let's dig into this a bit more. I certainly have a lot to share with you today. So here's our agenda. As I have done year after year, I'll update you on where we stand on the industry's federal priorities. This year, I'd like to give a timely update on the government shutdown and how that may be impacting your business, and then just do a sort of a broad outlook in terms of housing policy and give you a sense where NAA thinks the policy landscape will go from here. So let's dig into federal issues. I would like to cover a couple of issues on the congressional side and then on the regulatory side as well. So, in case you missed it or you may not remember, but the One Big Beautiful Bill Act was signed into law or was passed by Congress and then signed into law by President Trump. This is the most consequential piece of tax legislation in likely a decade, and NAA and our industry partners fought very hard to ensure that the industry would continue to keep favorable tax treatments that they enjoyed from the Tax Cuts and Jobs Act. So those were included in the final package. The bill also expanded access to the LIHTC program as well as opportunity zones. And you'll see thankfully here on my screen because we are certainly very thankful that members of Congress did not move forward with some of the pay-fors for this bill that would have been extremely detrimental to the rental housing industry. A couple I point out here for you are there was a proposal being bandied about to eliminate or reduce the deductibility of corporate, state, and local property taxes that would have created a huge financial burden for housing providers. So we're certainly very thankful that that did not make it into the final package. And you may have seen also bandied about was this quote unquote revenge tax, which would have put pressure on US-based companies that have foreign owners or investors and would have had detrimental financial impacts on those US-based companies as well. So certainly thankful that none of these made it into the final package, but that NAA protected the industry's interests in this monumental tax legislation. Hopefully, I'm not beating a dead horse here, but NAA continues to lead the industry's advocacy to eliminate enforcement of the CARES Act 30-day notice requirement. Firstly, we continue our work as the driving force behind the Respect State Housing Laws Act. We need this to be passed through Congress and signed by the president, which we have urged to put a finer point on the fact that this requirement was only a temporary emergency measure during the pandemic, and it ended in 2020 as Congress intended it to. Looking forward, we're also, in addition to our work to get the Respect State Housing Laws Act passed, we're continuing our efforts to eliminate enforcement measures across the federal government. I'm happy to report that Fannie Mae and Freddie Mac are no longer enforcing the CARES Act notice for multifamily borrowers. This is a huge win for the industry and certainly something that we're a part of our advocacy that we're very proud of. We're very thankful to Fannie and Freddie's conservator, FHFA, as well as both the enterprises for their attention to this issue of critical importance. You should also note that HUD is in the process of revoking its rule for project-based rental assistance housing providers to provide the 30-day notice. This would have made the CARES Act requirement permanent for this subset of housing under HUD's authority. And we are hopeful after the shutdown that we'll see some movement here. We do know that in their public announcement of their regulatory plan for 2025, HUD listed revocation of this rule as a priority. Wanted to make sure I also put a couple of important fair housing changes, which are hopefully on the horizon, and bring those to your attention. Firstly, you may remember that President Trump issued an executive order ordering agencies to eliminate disparate impact in all contexts to the greatest extent possible. While this is certainly a laudable goal, do keep in mind that the Supreme Court still recognizes the legitimacy of disparate impact claims under the Fair Housing Act. And so that's why, for NAA's advocacy on your behalf, it's critically important that we've asked HUD to revoke the Obama era, Biden era rule and replace it with President Trump's rule from his first term, which provides important safeguards for this type of litigation. And we're we're hopeful that this is on their list of things to do for by the end of the year, as HUD announced. This change in rule was also a part of their 2025 spring regulatory plan. Keep in mind that HUD's 2016 criminal record screening guidance, which is tied to the Obama era, Biden era version of the disparate impact rule, because it is linked to that, it must also be revised due to the executive order. And three things that I'd like you to remember on this front is NAA is in the process of providing HUD with recommendations on how to revise that guidance and make it more balanced. We have asked them to, one, ensure that bright line rules that housing providers can continue to develop bright line rules, those sorts of matrices and criteria that you and your companies put together that provide a very detailed list of the legitimate business reasons to screen. We want to make sure that that is protected. Secondly, we will be asking HUD to eliminate the individualized assessment requirement, which we hear from you introduces too much discretion back into the process, and certainly to some extent can negate the clear direction that screening rules and policies at a company provide. Thirdly, and I think equally importantly, we are also asking for them to reduce the amount of time that an applicant has to contest inaccuracies in their screening report that could have resulted in a denial of an application. We want to, provide more clarity in this regard and better streamline the screening process with this change. The other big fair housing development that I wanted to put on your radar is NAA has asked HUD to substantially revise their emotional support animal guidance. We had heard that, while well-intentioned, the 2020 policy from President Trump's first term needed more teeth to help reduce the volume of fraudulent requests that you continue to see. We have asked, I'd say, several things, but three main things I wanted to make sure to put on your radar that we've asked for is that we want HUD to maintain the process for evaluating a reasonable accommodation request for an assistance animal according to the Fair Housing Act. We want to separate that from the process under the Americans with Disabilities Act for public accommodations because the process to evaluate a service animal to be allowed in a public place for a couple of hours should differ from the process to allow an animal for the long term to reside with their owner in rental housing. Secondly, we are asking them to maintain what was in the 2020 guidance in terms of the differentiation between requests for domesticated animals commonly kept in the home versus unique animals. We want to continue in it to ensure there's a higher threshold for those unique animals. Thirdly, and is a big one, we are asking HUD that housing providers should be permitted to apply both animal rules as well as any fees, deposits, or other charges to all animals on the property, including emotional support animals and service animals. Why are we asking for this? We wanted to have some more, again, consistency in policy here. There is a recent Louisiana federal case that we can point to, which says that a fee for an animal may be charged for an emotional support animal or for an assistance animal rather, so long as this policy is applied to all renters at the community equally and it doesn't uh, impact one protected population um, in that process. The the caveat here is, according to the Louisiana case, if we are to get this move forward in a new version of the guidance, it would say that if a resident had already requested an emotional support animal or an assistance animal and that was approved, and now they're being assessed the fee, they would be able to ask for another reasonable accommodation request to uh, to let the housing provider know that they cannot pay for the fee because of their disability. For example, because they're on SSI and on a limited income, you would be required to evaluate that secondary request to have to waive that fee. Either way, we're very hopeful for a good outcome here. With this administration, we are very hopeful that we can work with them on their efforts for deregulation. There's certainly tremendous opportunity to align with the president's priorities in that regard and get some substantial reforms to the federal rules and policies that housing providers have to comply with. I would note here that there are about 1,300 political appointees that require Senate confirmation. These are the folks in key leadership positions that we're trying to get meetings with and to engage with to work on policy that's more balanced and certainly has the industry's perspective included. Of the 1,300 political appointees that Trump can nominate, only 264 of those positions have been filled and Senate confirmed. All that to say that in previous administrations, there may have been sort of a broader scope of people who had a decision-making authority to make changes in policy. But under the current framework, there's a very small population of folks in leadership that NAA and others are fighting for the attention of, and we're continuing our efforts to move NAA above the fray and make sure that our voice is heard on these issues. But just wanted to make sure you sort of understand the lay of the land of what the new normal in terms of engaging federal regulators looks like. So let's move to a timely update on the government shutdown. So as of this recording, we are now 23 days and counting into the shutdown. We're, I think, about 3 full weeks, 4 weeks since October 1st that the shutdown began. Wanted to make sure I put a couple of dates on your radar, both on November 1st. Federal workers will see on November 1st that second paycheck be missed. So that may put pressure on congressional leaders to get back to the table. Another deadline that's important to note on November 1st is you may have seen in the news that Democratic leadership is fighting for Affordable Care Act subsidies to be replenished and included in any continuing resolution to fund the government. those subsidies also expire on November 1st. So it's possible that that may also bring folks back to the table to have a fruitful discussion about the federal government reopening. Couple things I want to make sure that I note for you that are different than previous shutdowns is that, as always, only essential workers are working and they are working without pay. Couple of the wild cards here are that there is now an idea being considered that furloughed workers will and workers who are working without pay will not be given back pay. So there's a big question mark around that idea in this shutdown. Secondly, and the one you've probably seen more often talked about in the news, is there was a significant reduction in force that was put into place. That was a layoff of approximately 4,000 federal workers as part of that layoff. And we're certainly hearing that that number could increase up to 10,000 the longer that the shutdown persists. All that to say, we are continuing to encourage NAA members and industry professionals to work with their residents through the shutdown as your business allows. There are two big question marks around back pay for federal workers and the status of the federal workers who were potentially laid off. I'll talk about this on my next slide, but that layoff has been paused while it is working its way through the courts. You may have seen as well that there was a quote unquote clean continuing resolution passed by the House. This week, the Senate vote of that continuing resolution failed for the 11th time. We're certainly hopeful for a speedy outcome, but what the real wild card will be in terms of when this will end is, there is a thought behind the last shutdown that the only thing that brought congressional leaders back to the table was, I believe it was air traffic controllers at major airports stopped showing up for work. And so will that be the thing that gets folks back to the table? Or, will it be the amalgamation of things that are happening on November 1st that will really move the needle? We'll see. I wanted to just talk a little bit about some of the agency impacts that you may start to feel or may be feeling during the shutdown. Setting aside FHFA first, FHFA, the Federal Housing Finance Agency, is an independent agency that is not impacted by the appropriations process. They do not get their funding from appropriations. So they are the conservator over Fannie Mae and Freddie Mac. If you have any deals involving a Fannie Mae or Freddie Mac backed loan, those should not be impacted by the shutdown because, while Fannie and Freddie have been, deeply scrutinized and monitored over the years since the housing crash by FHFA, they are not government agencies and not impacted by the shutdown. So setting that aside, on the HUD front, it is our understanding from reviewing HUD's contingency plan and also, understanding the intel from what we're hearing in DC that that the Section 8 program did benefit from an advanced appropriation prior to the shutdown. You and your renter should see no interruption in Section 8 voucher benefits being distributed through the end of the year. Those payments have already been loaded into PHA accounts. So we are hopeful there's no disruption there. Same is true in terms of the advanced appropriation that Section 8 project-based rental assistance beneficiaries should not see any interruptions through the end of the year. A couple things to note on Section 8. You should be aware that HUD is keeping a limited number of their staff working to monitor this situation. They will allow PHAs to draw from HUD-held reserves if there is a renter household or family that is experiencing a financial emergency during the shutdown. or if it becomes apparent to staff that some PHAs can no longer fulfill their contractual obligations to housing providers, PHAs will be able to draw from those HUD-held reserves to make up for those potential shortfalls. HUD has also committed to continuing with contract renewals through this process to the extent budget authority allows. But certainly we shall see how much longer the shutdown will persist. In that some of these circumstances could change depending on how much money is left at their disposal. Also on the HUD front, just keep in mind that if you do have a deal with a HUD layer or certainly a FHA multifamily loan or HUD insured multifamily loan, those are going to be affected unless those contracts were close to closing prior to the shutdown. HUD has given regional directors across the country the authority to bring back staff to proceed with those closings, but only for those that were close to closing at the time the shutdown began, October 1st. If you fall into a category where you're in limbo, I have said this many times, but just to say again, NAA's job here as part of the government affairs team is to make sure that the industry's voice is heard and represented in policy conversations that Congress is having or that the White House is having or federal regulators. But our job is also to serve you. If you have a deal that's in limbo or payments that are in limbo and have a question, I do encourage you to reach out to me. We're here to help to the extent we can. We can, try to nudge some of our contacts in the federal government and try to get you an answer, but that's what we're here for. So please do reach out to me. Two more things before I move off the slide. We have heard that USDA Rural Housing Service Section 8 payments, those should not have an interruption through the end of the year. That said, where things differ in terms of USDA rural housing versus HUD, if you have residents receiving rural housing renter benefits, those benefits may not be available if a contract was pending at the time of the shutdown. Those you may not get paid for those or get an initial payment for those. And if a contract is in the process of renewal, there could be a disruption there as well. Again, for any of these things, please do let us know if you're in limbo in some way or another because of the shutdown, and we'll do our best to help you navigate through that situation. Lastly, before I move off of this slide, I had mentioned on the previous slide about the federal reduction in force. Those layoffs have been paused. That group of 4,000 federal workers who were laid off earlier this month, they remain in limbo. The unions for federal workers did sue the federal government successfully and were able to get a temporary restraining order for moving forward with that layoff. The rub will be on October 28th, the judge in that federal California case will issue their final ruling to consider an indefinite pause next week. We hope to have a little bit more information on the situation at that time, but just keep in mind when this situation has happened previously, those workers remained in limbo throughout the duration of when that case went up to the Supreme Court. So again, we encourage you to work with your residents to the extent that your business allows, but you will see that federal workers have, especially in areas that are close to DC, they may continue to have an unknown status and pay status until this is resolved by the courts. All of this to say that please do let us know if you, again, need help with a situation, and we are regularly posting live updates to our website. After this session, the Yardi Breeze team, I'm sure will make our PowerPoint text available so you can access this link. Please do let us know if you see anything that's missing from there. We want to make sure we continue to provide you with good information that's timely and also relevant to you. So let us know. So let's talk quickly about NAA's outlook on the policy landscape moving forward. Just to sum up my comments on the federal side, as you know, the federal government remains focused on deregulation. And, every 4 years when there could be a change in administration, there's always that risk that states and localities may step up their efforts to legislate where they see perceived gaps in either tenant protections or consumer protections that they view as openings being left by the federal government. Couple areas where we think that they will move in this space is fee transparency and disclosure requirements. That is certainly something to watch out for. While it is still a small minority of states that have fee disclosure requirements for housing providers across the country, that list is growing and it will continue to be a topic of discussion by policymakers next year. One thing that you should keep an eye on is the battle over utility billing as part of this process. For some states, they developed laws that were not clear in this regard. For example, in Colorado, there's a big question mark around whether RUBS can still be a valid form of utility billing under the new Colorado fee disclosure requirements. Massachusetts, the Greater Boston Real Estate Board. The Greater Boston Real Estate Board ended up having to work with the Attorney General to have, as part of his questions and answers on the fee law in Massachusetts, for that to have a utility question included, to put a finer point on that issue. So just to close, as I said, we're keeping a very close eye on fee transparency and disclosure legislation that is happening across the country, especially given that in the last administration, the FTC decided to exclude rental housing providers from its junk fees rule. In terms of AI regulation, you should continue to keep on your radar the rapid trajectory of legislation that is intended to ban revenue management software. We have just seen that California was successful in getting past statewide legislation. This is the first statewide law in the country in this regard. As things happen in places like New York and California, we know that they tend to spread, so we're watching this very closely as well. Of course, as part of this conversation, it certainly lacks an understanding of the legitimate business reasons to use revenue management tools, as well as the laws that are already in place to prevent or deter unfair and deceptive practices by companies. All that to say, we continue to support NAA's network of about 140 state and local apartment associations across the country, our affiliate partners. We'll continue to work with them to oppose bad policy and help provide a voice for the industry. Lastly, as we figure out how long the shutdown will persist, there will be a need for states to step up. We've already seen some states provide or let the public know, either affirmatively or not, that they will draw from reserves to make up for the budget shortfalls, but some may not. So you may see some version of legislation or regulation that increases fees for housing providers or for businesses to make up for these budget shortfalls in the interim. So stay tuned on that as well. Well, that concludes my remarks for 2025. I thank you again for the opportunity to get in front of you and give you a legislative and regulatory update for this year. I am happy to answer any questions you might have and look forward to connecting with you. Take care.